Now, Sri Tiruchi Siva.
Deputy Chairman, sir. Sir, it has been noted over the recent years that the judiciary in our country has been unable to deliver timely justice. For the reasons well known, that huge backlog of cases, vacancies in the judiciary, and thirdly, lack of policies and legislative proposals to improve the functioning of the judiciary. And what are the reasons for the backlog of the cases? There are so many, but to take one or two, sir. The arrears in the courts have arisen, whereas the number of courts have not increased to match the caseload. And second is the number of government litigations have arisen. That is, in the previous year, the total number of cases that are pending, 30 to 40% are that of government litigation. So to resolve this issue and to bring down, to reduce the pendency of the cases, the government introduced in the year 2009 a national litigation policy which reduced the average time to clear the cases from 15 years to 3 years. And in the year 2012, 25% of the cases across the courts were pending for more than 5 years. So later in the year 2014, the Law Ministry announced that a new national litigation policy will be formulated. The details of this is not available in the public domain. Sir, I think I don't want to reiterate, but I have to mention again that the number of cases in the Supreme Court, as everyone said, is more than 60,000, which amounts to 0.21% of the total pending cases. And in the High Courts, nearly 46 lakh, which amounts to 14.7%. And in the subordinate courts, it is 85%, sir. It is around 2.5 crore or something. It is 85%. So what could be done? My colleague, Mr. Sukhendu, suggested, I think, that though not non-mandatory, there must be a rational time frame. And that time frame should form the basis for the judges to dispose of the cases at the same time without compromising in the quality of the judgment. Just because other colleague also told that it should be a settlement and not a disposal. So when the cases are disposed, the quality of the judgment should not be compromised. So the time frame is a very basic essential, sir, and the creation of special courts. As I said, 85% of the cases are in subordinate courts. Out of that, 37.54 cases are very, very, very minor cases like that of traffic and police challan cases. So to address this, we can create special courts, special morning and evening courts manned by recent law graduates. I think these cases are very, very simple and could be handled very easily. Petty cases. To be in the right term, petty cases, 34.7% of the cases. And additional courts we need, sir. Additional courts must be set up for tackling the cases. And one suggestion which I think many of our colleagues would agree with me, the vacation of the courts. We have to reduce that, sir. Vacations in the higher judiciary must be curtailed by at least 10 to 15 days. Sir, it is a legacy of the British colonial system that during the summer season when the British were here, they have to go to the hill resort on something. But now that everywhere is air conditioning, even the court halls and everything. So when the cases are multiplying and they are pending for years together and many cases were cited here, which have been pending for 15 to 30 years, and so many under trials are languishing in the prisons without having proper trial. At the same time, the court is given a vacation for a longer time, to say even than a primary school, sir. So this must be reduced, only in the good interest, sir, in order to lessen. The traffic is increasing because of the increase in population, and we have to address that. So also when the population increases, the litigation will also increase. When an ordinary person in this country is hunted by power, is led down by police, not supported by the society, the only result available to him is only the court and the judiciary. And where he goes and waits for decades, where will he go? If he gets frustrated, in a democratic country, if he loses the faith in judiciary, his future is a very big question mark, sir. So I think these things have to be taken into consideration. And to address this, what are the measures that have been taken? As I think everyone has spoken here, that there are process that have been taken to amend the Civil Procedure Code and the Criminal Procedure Code, and so also the commercial division of High Court, commercial division in High Courts. Since the commerce and trade have increased, and the cases with regard to with the commercial disputes are increasing, and there was a bill which was introduced that there will be a division of commercial division of High Courts, which will deal cases which involves more than 5 crore rupees, and then a select committee suggested that it should be 1 crore, and the bill lapsed, and I think again the Supreme Court has also suggested the same thing, and the commission, the Law Commission has also recommended the same, that separate commercial division of High Courts must be established, which will go into the cases which involve more than 1 crore rupees, sir. So another thing is the arbitration. Arbitration is another method of disposing cases, which works under, as far as our country is concerned, by the Arbitration and Conciliation Act 1996. But over the years, several problems have been identified. What are the problems? Of course, arbitration is a very good method for disposing cases, but there are some problems which we have come across. What are they? One is delays in and huge costs associated with the arbitration process. Arbitration-related litigation which remain pending before the courts, and a challenge to an arbitral award makes it inexecutable and remain pending for several years. So this has to be looked into, sir. It has been observed that the framing of appropriate rules for the fixation of fees for arbitration, conducting continuous sittings of the arbitral tribunal, making the appointment of the arbitrator as a non-judicial act, and hearing international commercial arbitrations in a timely manner by the High Court will help the Arbitration Act to help for disposing the cases much faster. And another thing is the vacancy of judges, and as far as Supreme Court is concerned, it is 10% posts are vacant. In High Court, 35%, and in the Sabha district courts, it is 22%. Mr. Mishra spoke at length, and he was very eloquent, and he is a very senior lawyer who is experienced in the court. And where he is living in Allahabad court alone, it is 44% of the total vacancies exist only in Allahabad court. And next is our place, 12%. So this has to be addressed, sir. In the Department of Law and Justice has suggested that 25% of the judges' strength has to be increased, but we would suggest that it should be 50%. Considering the amount of cases increasing and the courts that have not been increased to match the caseload and the vacancies continuing, I think the future will face much more problems which have to be addressed very seriously. I think the incumbent law minister has a very huge responsibility. Sir, just 2 minutes more. Very huge responsibility before. It's not a sermon that is being deliberated here in this house. With all concern, all legal luminaries with all their experience and expertise have given you very good suggestions. I think your department addresses not only the Law and Justice Department, it has to coordinate with all other departments, and thereby I think all your efforts that has been taken will bring some solution to the pendency of the cases and the vacancies lying in the judiciary, sir. So also the infrastructure and the retirement age, the subordinate court judges retirement age may be enhanced to 62, and the High Court judges may be enhanced to 65, sir. So many High Court judges who want to become Supreme Court, if they are increased to 65, they will automatically go, and that will help them, sir. And so also the accountability of removal of judges. The Constitution provides that to remove a Supreme Court judge or a High Court judge, it's only by way of an impeachment motion brought either in the Lok Sabha or in the Rajya Sabha, which is not enough, is the opinion. Sir, all these years, sir, only our house has gone into an impeachment motion 2-3 years before, and it was a very great experience to all of us, and the deliberation that took place, and the leader of the house, then the opposition leader, only his intervention helped us to resolve that motion, sir, very successfully. That in all these years after the parliament has been established, that was only one example. So if at all, why this sort of lacuna means the clarity in the misbehavior which is defined to remove a judge. So they say that it is being suggested the creation of an independent body like a National Judicial Council will alone solve. So also we have, by way of the 121st amendment, we have brought in the National Judicial Appointments Commission, which replaces the collegium, which is also pending in the Supreme Court. Sir, why that all these things? The Parliament is enacting a law and it amends the Constitution for the appointment of judges, but the Supreme Court is holding that. So also the impeachment motion, which is not enough to satisfy what is to be done, the National Council, which is being expected, is pending. So also, sir, as many other members here shared, the Supreme Court bench is needed in the South. It is being demanded for quite a longer time. Only the Supreme Court is rejecting, sir. And second is that as per the Constitution Article 348(1), the regional languages could be used in the High Courts and Hindi, other than English. And based on that Constitution, when our leader was the Chief Minister of Tamil Nadu, the Assembly passed a unanimous resolution and it was sent through the proper sources. The Supreme Court again stalemated that. What the Supreme Court is losing by way of enabling the High Courts to use the regional languages, we do not know. So, sir, we need a Supreme Court bench in the South in order to enable the litigants. Sir, the judges should not only look at the courts functioning, they should also look at the litigants, and the regional languages must be allowed to be used as languages in the High Courts. And third, and most of all, reservation policy must be adopted in the appointment of judges, whereas it is adopted in all other cases, sir. With these words, I expect much from the Honorable Minister, who is capable of, and I hope that some light will be thrown in the Department of Law and Justice in the coming days. Thank you very much, sir.
See, Tiruchi Siva, when I was a Lok Sabha member,
Sir.
I introduced a private member's bill,
Sir.
asking for a Supreme Court bench in the South.
Sir,
But long.
thank you, sir.
Eh? Eh? Here I don't remember, but
So only the Supreme Court is not allowed.
it was in
so the government's
in the
intervention,
80s.
the
In
government's
80s.
intervention could
in
solve
the
it, sir.
80s.
Yes. So the government's intervention, I think, will solve the issue. Sir.
Actually, it's a very genuine demand, because actually a person from the South to come to the Supreme Court and conduct a case, it is very difficult on one account to come to Delhi. Second, the exorbitant fees to be paid to the. So actually, justice is not being given. That is the real thing. Yes.
Similar
Yes, sir.
demand was made to set up a Supreme Court bench in Guwahati.
Yeah.
Which is too far.
Yes.
I think
I am not disagreeing with that.
it has
Is
been
that
long
correct?
years.
Yeah, Minister
In
was to say
90s the
something.
demand was made.
Minister
But
was to say
till
something.
now it is not under consideration of the
Minister
government.
was to say
Will the
something.
minister consider it?
Okay, agreed. You were to say something? You? Okay, all right. Now then I will allow you. Come. Now Praveen Rashtrapal? Nahi hai. Then Dr. Keshav Rao? Nahi hai. Okay, then you take only 1 minute.
Litigants must also be communicated in the language they understand. If Tamil Nadu High Court cannot have Tamil language, will the Tamil language be introduced in Patna or Paris? It is a colonial hangover, and the demand of the people is that they have to spend a lot of money to understand the judgments given by the High Court. So it is the demand of the people. Likewise in Karnataka also, Assembly has passed a resolution. So will the Honorable Minister also give us an idea that when Tamil will be introduced in Tamil Nadu High Court?